Good morning. How's everyone doing? Good, good. Did you have a good weekend?
Yes, ma'am.
All right. So this morning we have 4 cases on the docket. 2 are set for argument, 2 have submitted on the briefs. And today is Monday, May 22nd. The first case we have on the docket is State of Ohio versus Eric Jackson, case number C220458 that has submitted on the briefs. Then we have case State versus Shelton, number 220513, also submitted on the brief. And then the first case we have set for argument this morning is State of Ohio versus Riddle, C220506. If attorneys can identify themselves in the readiness to proceed.
Laura Peters for the appellant, ready to proceed.
Sean Donovan on behalf of the state, Your Honor, ready to proceed.
Thank you. And then the fourth and last case we have that's also set for argument is Environmental Solutions and Innovations, Inc. versus Casey Swecker et al., case number C220634. If attorneys can identify themselves and the readiness to proceed.
Good morning, Your Honor. Susan Argo of Bricker Graydon. My partner, Mike Roberts, is here, and also Virgil Brack and Tina Brack of Environmental Solutions.
And you will be the one arguing this morning?
Yes, Your Honor.
All right, thank you.
And good morning, Tom Glass here for the appellee. I'll be the one arguing this morning.
Okay. Alrighty. And you're the only one here on behalf of the appellee?
That is correct.
All righty, very good. All righty, Attorney Peters, whenever you're ready.
Good morning, Your Honors. I would like to reserve 3 minutes.
Okay.
May it please the court. My name is Laura Peters, and I represent the appellant, Rodney Riddle, in this matter. My plan is to discuss the first and second assignments of error, and I will entertain any questions the court has, obviously, for the third assignment of error. And please indulge me, I've been struggling with my voice a little bit lately, so. In this case, we have Mr. Riddle, who appeared before the court the day after he was arrested. And he was supposed to, according to Criminal Rule 5, there were certain rights the trial court was supposed to inform him of. Those included the right to counsel, and he did have counsel present with him at that hearing. The right to remain silent, and the right to a jury trial. But if he was facing if he was charged with a petty offense, he was to be informed that he had to demand the right for a jury trial. Fast forward 2 months, and they come to the bench trial, and that morning, counsel requested a continuance because Mr. Riddle had been under the misunderstanding that he was always going to be facing a jury trial.
So in that initial hearing that you referred to, your whole argument is premised on that he was not informed of his right to a jury trial or his requirement to specifically request one in order to invoke it.
Correct. Actually, the transcript of the July 28th initial hearing is before the court, and actually the trial court doesn't go through any of the constitutional rights, but the one that we are focusing on, yes, is the right to a jury trial and the requirement that he would have to demand a jury trial within 10 days before trial.
And I'm assuming you're getting to the point of where the continuance is requested?
Yes.
How many
Yeah.
hearings had there been before the continuance was requested?
There was one pretrial hearing, and that was on August 12th. And in that case, defense counsel did request a continuance for another pretrial. And the purpose was, though, because they were just given discovery and there was more discovery to come. So you can't really blame the defendant in that circumstance when you can't expect an attorney to go forward with trial when they've demanded discovery and it hasn't been provided yet. So there was one prior continuance, and then the next pretrial, they there was another pretrial, and then it was the trial date was set for September 27th.
Does it make a difference if he has an attorney or whether he doesn't have an attorney at the time that that preliminary hearing is taken?
Your Honor, no, I believe it does not make a difference whether or not he has an attorney, because whether or not he has an attorney, this is an obligation on the trial court. This, Criminal Rule 5 doesn't mince words. It says the trial court shall inform him. So this is substantially similar to what Criminal Rule 11 requires before accepting a guilty plea or a no contest plea. So whether or not he was represented by counsel doesn't negate the trial court's obligation to inform the defendant of the constitutional rights at that preliminary hearing.
Now, I noticed all the cases that you cited, the defendant in those cases did not have counsel at the time of the hearing.
I'm not sure that's true, that all, I know there was a couple, but I believe it's unclear in the second district case, Houston, whether or not he had counsel at that initial proceeding. It doesn't mention that one. And in Houston, though, it's substantially similar. It was I believe it was a theft charge, a petty theft charge, and the counsel in that case made the demand for a jury the evening before the trial. It was the first time, and so the issue of Criminal Rule 5 was raised on appeal when the trial court wouldn't allow them to have a jury trial and required them to go forward with a bench trial. And the second district in that case said there was a fundamental flaw in the proceedings because the trial court didn't comply with its obligations under Criminal Rule 5. I would have to double check. I do know you are correct. I believe in the Eastley case that we cite, or I'm not sure I cited that. There was a pro se defendant, but this was discussed in, I believe, one case where they talked about the right to counsel, and the court said, well, it's arguable, but because this is such a fundamental right and this is an obligation of the trial court, then then the trial court needs to meet its obligation regardless of whether there's counsel present.
Ms. Peters, are there any cases that you found where it is clear that the defendant was represented by counsel at the arraignment, at the first hearing, and was denied a right to, wasn't informed of the right to a jury trial, or that the defendant had to ask for one, and the appellate court found that I'm sorry, that the appellate court reversed in that situation? I didn't see any. Because the Baronetto case, I couldn't tell in that case if the defendant was represented at the first hearing.
I looked at that one case this morning again, and like you, and like the Houston case that I mentioned from the second district, they don't mention whether or not the defendant was represented by counsel at that initial hearing. And so it's hard to say. And again, I'm not sure in the Wilson case where they talked about the arguable merit of having an attorney. I'm not sure if that one was clear on whether or not there was an attorney present at the time of the initial hearing.
Well, it says to me on that one that there wasn't, because it says that the appellant did in fact have the benefit of legal representation during the trial proceedings after his initial appearance.
Okay. Yeah, I'm just misremembering then.
So on the flip side of that, are there any cases that absolutely 100% say that if the defendant is represented during that initial hearing, then there's no error, no reversible error?
I would say the closest case that I recall, and that was cited in the state's brief, and I believe I mentioned it in my reply brief, is this out of this court, where it was clear that the defendant had an attorney present.
But there were distinguishing.
But that's what I was going to
Yes.
say, that there's distinguishing factors because the criminal rule 5 just came up on appeal, and there was no request for a jury in that case. So here it's distinguishable because the defendant did clearly request, they requested a jury trial, or they requested a continuance because they wanted a jury trial.
Thank you.
So I can't find any case on point on that. I don't recall.
Mr. Peters, was your client arraigned by the trial judge, or did he go through one of the arraignment rooms, like room A or?
I believe he
maybe
was
the
in room
courthouse?
A. I have the transcript, I can double check
Do
it.
you have the transcript from room, you have the transcript from room A? Well,
Yeah, I do.
Don't look for it. But my recollection was that in room A, that the judge would read the Rule 5 advisements en masse to everybody that's sitting back in the audience and people back in the lockup. Is that still the practice over there, to go over those rights?
That en masse reading is not
Yes.
reflected in the transcript.
Right, but does it still happen?
And I consulted with some of the attorneys in my office
Right.
that went through room A, that do room A,
Yeah.
and I was told that no, they do not do that.
You don't read it? Okay, all right.
But that's not part of the record either.
Right.
but-
I was just curious.
Yeah,
Attorney Peters, can you address waiver?
waiver.
Yeah, in other words, was this raised below, and was it raised in a timely fashion?
Well, I would argue waiver isn't actually the correct term to use because waiver is a known relinquishment of a right and you sign it away. So because, one, we have the trial court not informing him, so he doesn't know it. And I would believe it is preserved because he did raise the issue.
Well, I think that's where the fact that he has counsel becomes interesting, because the counsel is deemed to have known that rule, which
Correct.
also then raises the interesting question of ineffective assistance of counsel.
It would be hard on the record in my estimation, to raise ineffective assistance of counsel because there was a disagreement between counsel and the defendant as to whether or not they had discussed this previously, and that was placed on the record. So I don't know that the record would affirmatively show that counsel was ineffective, but he also then mentions that there was a breakdown in communications, and that may be where Mr. Riddle just didn't have the understanding, and that if it had been made clear to him, like the trial court was supposed to tell him at that initial hearing, hey, you have to demand a jury because you're charged with a petty offense, then that might have stuck home with him more. And we can't really get into, we don't know the attorney-client privilege. There wasn't a lot put on the record, except that, yes, defense counsel represented that they had these conversations, so I chose not to raise ineffective assistance of counsel because I didn't think the record would bear that out.
Understood. Okay.
But again, that's why I was focusing on criminal rule 5, because this is really what the trial court is required to do.
I'll give you a few seconds to wrap up.
Okay. And obviously, if the court doesn't want to go with the criminal rule 5, there's the issue of the continuance. I mean, this was the first trial continuance that was requested. The other one was because the state hadn't responded to discovery. And the only reason the trial court was really stating was because parties were present, the witnesses were present, but no one asked the witnesses whether or not it would be a great inconvenience for them to come back. The length of the delay wouldn't have had to been great because all they needed was the 10 days and be due to the misunderstanding. So we would ask that this court reverse and remand for any trial in this case.
Thank you.
Thank you.
Morning, Your Honors.
Good morning.
Perhaps since I think it's the easiest of the different questions that I heard to resolve, Judge Winkler, in terms of the en masse reading, we don't have that in the record. I didn't try to make that argument. We don't have any of the forms from room A and everything like that. But what I would say is that, and this kind of goes, Judge Bach, to your question about representation at that initial setting and the discussions about that. I don't believe that it's per se in either direction. It's not per se if they didn't have counsel and they weren't notified, or even if they did have counsel and they weren't notified. And having counsel doesn't per se inoculate the proceedings from it. We don't contest there was not a discussion about the necessity to demand a trial in a misdemeanor case. That's clear. We concede that point. The distinction then comes that later on down the line, as this court has held in cases and other courts, that where there is counsel, like in, I believe it's, I'm going to mispronounce it, SU, HSU, and I apologize if I'm mispronouncing that case, but in that one, represented by counsel every step of the way, and then didn't raise the issue until the first time on appeal. That's clearly not the same case that we have, but the court found that that waived the issue if you didn't raise it until then. Here, and I know that I used in my brief, I used the term waiver, and that was probably inartful, inaccurate to use waiver. I think that it's necessary that, given that it's not a per se violation, that the court then evaluates the totality of the circumstances presented to it. And in this case, the defense counsel made the affirmative statement, which we don't have in any of the other cases. In the cases where it's been ruled that it was prejudicial, you didn't have in the record counsel saying, we spoke numerous times, we talked about this, he said he wanted a bench trial. And then the defendant contradicting that. And the court said, I'm well aware, I'm well acquainted with this counsel, he is well respected, I respect him, and I respect what he's saying. And I believe that that's indicative of a credibility determination in terms of which side the court was taking. And I think that particularly if we kind of view it as a combination of the denial of the request for a continuance and the standard in that, the court's, the trial court's determination there is entitled to a certain degree of deference in terms of that. The court had the opportunity to view all of the participants, had been there at every step of the way, except for since it was room A, they weren't. I don't know that they were the room A judge. I don't believe that would be unusual if they had been the room A judge as well. But I think that the court's determination there is entitled to some deference. In terms of coming back to room A and whether or not it can be per se a violation, per se prejudicial, I would point out that defendants don't even need to appear at the initial arraignment. So their presence can be waived by counsel at that initial appearance. So if counsel can waive that presence.
And I think that gets me then to my first questions, but I'm going to ask it to you a little bit differently now.
Yes, ma'am.
Let's say that the record is absent of that colloquy between the trial attorney and the trial judge with regard to any discussion on the right to, on the invocation of the right to jury trial. Would you say that there's anything difference between a preliminary hearing where the defendant is represented and unrepresented with regard to the trial judge's absence of the Rule 5 colloquy?
If I understand your question, and
In other words, let's take this record and it's silent.
Yes, ma'am.
Because that was like, when you were looking at the totality of circumstances, you were relying on the record.
Yes, ma'am.
Yeah, so we're going to make it silent now, right? And everything else remains the same.
I would, under that hypothetical, in that situation, and also taking out defendant's presence when it was referred for a bench trial. We'll take that fact out as well, because I believe that would also go into the totality of the circumstances, his presence there when that is in. Taking those factors out, if the record is completely silent on it and there is no comment, I'd be in a much, much harder position, and I would be in a position of saying that we have to make that presumption. And I believe that there are cases that counsel cited that said that we can't make that presumption I don't believe this court has ever ruled definitively on that, but there's certainly case law that says that that presumption cannot be made on a silent record just because they have counsel. And that's not what we're arguing for today, and that kind of comes back to when I was addressing Judge Bach's question. We're not arguing that having counsel at every stage per se inoculates the proceedings, that there must be something more in the record. So I'm not sure if I've actually answered.
You're answering my question, yes.
Okay.
Thank you.
In terms of the...
Because what I find interesting
Yes,
is
ma'am.
this, that there's a presumption that counsel knows the rules. Otherwise, there's something called ineffective assistance of counsel, right?
Yes, ma'am.
So I think that the factor of the counsel there makes it sort of interesting, because then is it a Rule 5 violation or is it an IAC?
Indeed, and I would say that in terms of the ineffective assistance claim, or in terms of a claim like this that would rely on the discussions that have been had off the record and everything like that, it could be addressed in a post-conviction motion.
And then that's exactly it. So with this case, yeah. And I think the challenge there is it depends on what we speak of whether that is going to somehow trump the opportunity for post-conviction inadvertently.
And the one thing, and I'm certainly not complaining about the procedures, we don't have that from the state's point of view. We don't have that opportunity to raise that issue. So I think that a certain amount of deference to the court's determination in a situation like this, it goes back to that deference, because if the court's wrong, if the defendant can put together in a post-conviction, counsel says, yeah, we never had this conversation, then I believe that would certainly substantiate or be a strong factor.
Right,
in
but
an
then it would
ineffective
have to be a very
assistance claim.
compelling affidavit. That's where the challenge becomes.
It would, yes, ma'am, absolutely. But I do think that it's then incumbent to have this discussion on the record. It would be incumbent on the trial court to inquire of counsel on that matter. But we then come back to your initial, or maybe not the initial question, but one of the more recent questions about per se and if the record is silent. And I do believe that I don't want to concede that because I haven't directly researched and argued that, but I would have a very hard time arguing against that if the record is completely silent.
So it sounds like your argument is that if counsel isn't present, then it's per se.
If counsel is...
If there's no counsel, then it would be a per se violation. But if counsel is present, then it's a totality of circumstances review. Am I?
No, ma'am.
No, okay.
So to clarify, and I've been unclear, in terms of if it's uncounseled, I think that if we had the same sort of situation where if it's per se, it doesn't matter. He could, the defendant could come up and say, yeah, I knew I had to ask for a jury trial, but I didn't. And if it's per se, it doesn't matter what happens afterwards. The only thing that would matter is whether or not there was compliance at that initial arraignment. So I don't believe that per se in either direction, whether counseled or uncounseled at the initial arraignment, can be per se, or whether they're represented later on down the line. None of that.
I think Attorney Peters would respond to that on the shall language of the statute.
Absolutely, but the shall language is still there and still evaluated in terms of, shall, but it can still be waived. Shall. But if there is indication, affirmative indication on the record that they were well aware of this, the cases that talk about a presumption of it say, we don't know whether counsel discussed this with them or not. And so if there was a discussion, then there was no prejudice. And so then, there was a conscious decision that was made. So yes, it is shall. However, shall doesn't necessarily mean that it is an obligation.
So it sounds like your argument is shall, however, it could be harmless error. I think that's,
I guess so.
and so
I mean,
the totality of the circumstances can
I believe that there
raise
still needs
harmless
to be an
error.
evaluation of the circumstances surround how it came up in this particular case. And in any case, the subsequent litigation hearing record and the subsequent facts that are elicited, and in this case, counsel definitively said, we talked about this. He said he wanted a bench trial. And then that goes towards the Unger tests in evaluating whether or not it was reasonable for the court to deny the continuance. The court has clearly found that Mr. Riddle contributed to the reason for the request for the continuance. And this court has said that when witnesses are present, it is not an abuse of discretion for the court to find a significant inconvenience to those witnesses to make them come back in there. So I think that those two are my strongest of the Unger. Prior continuance, it was normal. Nothing unusual there. I would say that the request for a continuance because of discovery, it was less than 2 weeks after arraignment. I don't think that it's unusual that discovery wasn't completed within that initial 2 weeks. So I don't think that cuts in either direction on the prior request. But Mr. Riddle being well aware of it, according to counsel, is definitely a factor that the trial court took into consideration in denying the request for a continuance. And we would just argue that regardless of whether it was represented or not represented, we have to look at the totality of the record to determine whether or not there was prejudice, whether or not it was a conscious decision to waive. And I believe that on this record, it is established that Mr. Riddle was well aware of that it was being set for a bench trial.
Thank you.
See if there are no questions. Thank you, ma'am. Yes.
Judge Winkler, to answer the question you asked me, it was a room A, Judge Johnson. He was tried before Judge Berkowitz.
Right,
So-
I do.
So it was different.
Now that thinking back, when they read those, the court reporter might not even be there.
I respectfully would say that the attorney's presence doesn't change what Criminal Rule 5A requires, and that is that the trial court shall inform the defendant of these constitutional rights.
I think on that part, the state seems to agree with you, but then they take it to the next step and said, regardless, one is to look at everything else, that's what's being referred to as the totality.
And I don't see any case law that actually said it, that you examine this under the totality of circumstances. In contrast, the 4th, the 6th, the 2nd, the 9th, and the 11th, in cases I cited in my brief and reply brief, have all said that it's a fundamental error and it's prejudicial to the defendant when the trial court fails to comply with Criminal Rule 5.
So if indeed the trial court made a credibility determination and determined that Mr. Riddle's counsel did discuss this with him, that he had to make a request for a jury trial, is it prejudicial?
Yes.
Can you explain that?
Because it's what the trial court is required to do it. Because that way it's on the record. And everyone knows then that the defendant has been informed that he has to demand the right to a jury trial. Absent that being on the record, you have to invade the attorney-client privilege to try and make a credibility determination. So, again, the Criminal Rule 5 isn't aimed at defense counsel, it's aimed at the trial court, and it tells you what the trial court must do. And in this case, the trial court failed to comply. And so we request you reverse and remand for a new trial so Mr. Riddle can have the jury trial that his constitution provides him. Any other questions?
Thank you.
Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. Have a wonderful afternoon and a great week. I'm going to take one little pause because I need a pen. Mine is not writing.
There's,
Yeah, it writes.
does that look familiar?
Gee, this looks familiar. That's good. Okay, we got one. Okay, thank you. Just in case.
That actually has my,
You want yours?
yeah, that's my, okay, so.
All right, thank you. So this is Environmental Solutions and Innovations. Good morning. Would you like to reserve time, Attorney Argo?
I would. I would like to reserve about 10 minutes for any questions that the court would have.
I'm sorry, can you repeat that?
Yes, I would like to reserve about 10 minutes. I believe my
Okay.
argument on direct will be very brief.
All right.
So I'm going to be addressing the first assignment of error.
All right, whenever you're ready.
Yes, thank you, Your Honors. May it please the court. My name is Susan Argo on behalf of Environmental Solutions and Innovations, Inc. We're here today on the court's decision dated November 29, 2022, granting the appellant's summary judgment on ESI's claim for tortious interference with contracts. The reversible error is very simple. The lower court applied the wrong standard of review in granting the motion for summary judgment and direct contravention of the binding authority on this court's 2021 decision of Wigton versus University of Cincinnati Physicians, Inc. There is no reason for this court to look any further at the merits because the motion was assessed under the wrong standard.
Oh, I did notice that the trial court did cite summary judgment in the entry.
Yes, he
So
did.
the trial court was aware that not only this was a summary judgment, but what's the standard that's applied in a summary judgment?
Correct. So he cited that Rule 56 very early on in the decision, but more importantly, in his decision, he says plaintiff must establish each factor by clear and convincing evidence. And what this case is identical
And I'm
to.
assuming that the argument will be, well, he was talking about what has to happen when it proceeds to trial.
But why? But he's, yes, well, I think that that's misguided, if you will, because his decision then, this is exactly on point of Wigton, is what I would suggest to the court. Because procedurally, in non-compete cases, the majority of cases are done in the context of injunctive relief. And actually, there's clear distinction to the court, what the court did here. This court and the First District Court of Appeals, you have your Castillo-Sang case. That addresses injunctive relief and the clear and convincing standard. In a motion for summary judgment, this is exactly adverse to that. They're just establishing whether there's a triable issue of fact that exists. And just like in Wigton.
Well, and I think to your point, they're also establishing whether the moving party is entitled to judgment as a matter of law. And I think that's to your point in the sense of
Yes.
When you're looking at that, you're looking at it from the lens of motion for summary judgment.
Yes, I guess if he's applying, though, a clear and convincing standard, what's important procedurally about this case is it's somewhat an outlier like Wigton. We did not seek injunctive relief. And so when the court, even in Wigton, makes that clear distinction that there's injunctive relief and then there's the motion for summary judgment standard. And, the citing of clear and convincing evidence and finding that there was no, holding ESI to that burden of proof, it has no place in a motion for summary judgment argument. The court in Wigden made that very clear. It has no, because it presupposes the weighing of evidence which the trial court should not undertake at summary judgment. It completely flies in the face of
How
it.
should have the court looked at the 9 factors then?
The 9 factors is whether there's a triable issue of fact, and he held them to too high of a standard. And so,
Isn't there 2 parts? There's more than 1 part to summary judgment. One is whether there's a material issue of fact, a triable material issue of fact. The other is whether the moving party is entitled to judgment as a matter of law.
I agree with that, but he held them to too high of a standard on determining whether there is a triable issue of fact. And what I would also point out for this court is that in his analysis, he did not weigh each of the cross motion for summary judgment separately. There's nothing in the record at that
But you
point.
keep going back to tribal issue of fact. What if both parties were in agreement of the facts and there was no conflict in the facts? Does that mean that the moving party is automatically entitled to summary judgment?
If there's no issue of fact, then it would be appropriate for the court to grant summary judgment. But we're a long way from that because he placed...
Well, what if there was no triable issue of fact, but yet the factors have to be weighed in order to determine the outcome? And then there's weighing of the facts. And
So,
it-
okay, yes.
Do you understand what I'm saying?
I do understand what you're saying. And when you're weighing those factors, he held them to a burden that is too high. This court points out that it places too heavy a burden on the thumbs on the scales of
That gets
ESI
me to
having...
my other question. How
Okay.
should have the 9 factors been reviewed?
They should have been reviewed for whether there was an issue of trial, if there is a dispute of fact in those 9 factors. And our position is clearly there was. He did not review the affidavit of Tana Brock. He's supposed to take that evidence and assess it, all of the evidence.
What was the disputed issues of fact that were relevant in this case?
In this case, I think it's very important to understand what was at issue here or being restricted. It's that these people were provided time, energy, effort, and training efforts to obtain certain permits in order to do the work that ESI does.
And was there an issue? Was there a dispute as to what that time, energy, and training was?
It was never even addressed by the other side. That factor was in our favor, and the court just ignored it. He looked at a few affidavits and the agreements themselves and did not weigh the factors. And so when you're weighing those factors, I would suggest that the standard of review is whether there's a triable issue of fact versus in injunctive relief, you have to prove the substantial likelihood of success on the merits under a clear and convincing standard. And that is exactly consistent with the Castillo-Sang case here. When you look to Wigden, this court says that plaintiff must establish each factor by clear and convincing evidence. That's just plain error. He's supposed to assess it under whether there was a triable issue of fact. He identified none in his decision. We would suggest that it demands that the court remand this and instruct the court, to assess the motions for summary judgment under the appropriate standard. Is there a triable issue of fact? The court on a motion for summary judgment.
Understood. If you want to reserve your 10 minutes.
Yes, I will. Okay. Thank you, Your Honors.
All right. Good morning, Attorney Glassman. How are you?
Good morning. Thank you. I'm here this morning to ask you to affirm the decision of the trial court. And I think the right jumping off point is to point out, as we addressed in our motion at the trial court level and again in our brief, that courts take a very harsh look at non-compete agreements and generally disfavor them. And we see that right now, for example, with the proposed rule that the FTC is considering, which would just put the kibosh on non-compete agreements completely. And if that rule, in fact, is adopted, then this makes what we're doing here this morning an academic
But
exercise.
it hasn't been adopted, so.
Correct.
Let's go on and argue
Yes.
the case.
But the reason I mention that is just to show.
No, I understand,
Yeah, 'cause
I understand,
it
but that's
ties in
also
that,
outside of our record.
The way it ties into this is because of how the courts disfavor these agreements, that is why there's a heightened standard of review. And in fact, there are a number of types of civil claims that are held to a clear and convincing standard, regardless of when they're addressed in the course of the proceedings. For example, certain types of fraud claims, regardless of whether it's at the summary judgment level or the trial level, are held to a clear and convincing standard.
Mr. Glassman, let me, under
Yes.
those, the 9 Ramundi factors, doesn't that necessarily require the court to weigh those factors in making its determination on summary judgment, which is prohibited by summary judgment? The court weighing, I mean, in your summary, motion for summary judgment, you argue, first you argue that it must be demonstrated by clear and convincing evidence, then you talk about weighing the scale. So do you think that's this sort of thing, although I know other courts have done it, do you think summary judgment is appropriate when the court is required to weigh certain factors in the record?
Well, I think here, weigh can be a subjective term. So if, for example.
You argued that the court ought to weigh those
so
factors.
if you're using weigh in the context of, hey, I'm assessing credibility, that witness A says this and witness B says that, and they contradict each other, but I think witness A is more credible than witness B, so I'm going with witness A, then yes, that's a problem. What we didn't have here, and in fact, because we had cross motions for summary judgment, which seems to indicate that both sides felt that there were no genuine issues of material fact. I don't think we had that scenario with the trial court where the judge was weighing credibility of one witness over another or one piece of evidence over the other, because in fact, the trial court's decision took great pains to state at the beginning that the judge was following Rule 56 in considering the evidence in the law.
What would some of the considerations in the judge's decision involved where these employees received their training, their relative youth, the fact that, if the contract were to be enforced, it's their sole means of support, those sorts of things. And what I'm getting at is it seems to me that the court did, in fact, weigh those factors. And is that appropriate?
Yeah, I think, the court, looked at all the factors together to see how they interplayed and didn't just say, pick one factor at random and say, hey, I'm basing my decision on the fact that this particular factor wasn't satisfied. The court did what they were supposed to, that the trial judge went through each of the factors and considered them in reaching the ultimate conclusion, and that was the appropriate analysis. It wasn't a situation where the court was weighing credibility one way or the other. The court looked at all 9 factors together in reaching the decision, just like the court mentioned that it was considering each individual's affidavits and unique circumstances.
Counsel, it sounds to me, reading your brief, it sounds to me like you are arguing that the Wigton case, that we should, that's not good law.
Yeah, with all due respect to this court, and I'm keenly aware that 2 members who were on the Wigton decision are in front of me this morning. So I do think Wigton is at odds with what other Ohio courts have done on this issue. And in our
Are
brief,
we bound by other courts, though, other than the Supreme Court?
No, but I think, for example, and I don't want to get too far ahead of myself because we're still at argument this morning, but it might lead to a scenario then where the issue may need to get certified to the Supreme Court, because we did cite to, I'm not aware of any court outside the First District, and again, I mean no disrespect with this line of argument. We couldn't find any line of decisions outside the First District that take the approach that was taken in Wigton. So perhaps certification to the Supreme Court may be appropriate because other state appellate courts, plus the Sixth Circuit, have taken the approach that we deem to be appropriate.
So would you say if we were to follow Wigton that it would need to be remanded?
No, because since the standard of review that we have before you today is de novo. And since we have a situation where both sides were telling the trial court that they felt there was no genuine issue of material fact, that even if you were to employ the standard that the appellant advocates, even under that standard, summary judgment in favor of the appellee would still be appropriate.
And so it is your position that there was no issues of material fact?
Correct.
Okay. Because obviously enforceability is an issue of law.
Correct. Just to close the loop on one thread that I started a little bit earlier when we were talking about the clear and convincing standard, I mentioned how fraud claims, regardless of what phase of the proceeding, are subject to that standard. The same thing with certain types of defamation claims. Again, whether it's a summary judgment phase or trial phase, they're held to that standard. If we were dealing with punitive damages, again, that standard is applied regardless of which phase of the proceeding. So that all ties to the courts realize that certain types of civil claims should be subject to a higher standard of proof than others, which is why you see in certain specific and discrete categories why the courts are advocating for the clear and convincing standard. And nevertheless, courts decide all the time motions for summary judgment involving fraud, involving defamation, involving punitive damages, and they're still able to do that even with the clear and convincing standard. But like I mentioned a moment ago, even if you were to take appellee's approach, under the 9 factors, we think we've demonstrated that we're still entitled to summary judgment. And if you look at the evidence presented below, this was not a he said, she said type case, because neither side felt there was a factual dispute, which is why both sides were both advocating the trial court for summary judgment.
And I want to make sure with regard to your last comment, which is whether there is a material issue, what you referred to as he said, she said, right? I'm looking at factors 4 and 5 of the 9 factors. Do you want me to read them out, or you?
Oh, no, I don't care.
Okay, so what is the evidence on the record on both sides with regard to those factors?
Yes, because the situation we have here, which is really somewhat unique for non-compete cases, if you look, not every employee in the group who left had non-compete agreements. And what made those employees unusual is that all of the higher level employees who left, and people who were on a management level or leadership member level, none of those people had non-compete agreements.
But was it a timing thing? Because wasn't there a period of time where the company was not executing them, and then a time period in which they began to execute them?
Correct. So for the people on the higher level, when they began their employment, the practice wasn't in place. But even still, as the evidence that was before the trial court indicated, this practice of having entry-level or low-level employees entering into these agreements is still somewhat anomalous in the field. For example, the Edge employees who were deposed testified that the only people employed by Edge who had non-compete agreements were people who actually had an ownership interest in the company. So people who were in senior levels of management but didn't have ownership interests didn't have such agreements. And so, for example, Casey Swecker, when he was initially hired by Edge, didn't have an ownership interest in the company and didn't have a non-compete agreement. It was only after that he became a shareholder or member of the company that he was asked to sign one. So we have a situation here where you have people with a specific level of education and a very focused discipline. It's not like medicine, for example, where, okay, I can't practice radiology in Hamilton County or Ohio, but I can move to Kentucky, I can move to Illinois, get licensed there and do radiology. With these types of agreements and the type of work these people were trained to do, if these agreements were enforced as if written, it would essentially make these people unemployable for the period of 18 months.
Wasn't it just east of the Mississippi?
Geographically, that's correct, but because of the nature of this work, the majority of aquatics work, as was set forth in the affidavits, is going to be east of the Mississippi. So is there aquatics work west of the Mississippi? Yes, but the great majority of it is still going to be on this side of the river as opposed to west of the river. So it's not just a matter of drawing a line down the middle of the country saying, go do your job in the other half. This significantly constrains what people are able to do to earn a living. And again, these are people who are not on a management level or leadership level. These are simply people who were, with no disrespect, you're basically doing grunt work. They were the ones going out in the field, putting on their waders, getting in the water, getting dirty, doing the scientific analysis, as opposed to the leadership decisions or involved in the day-to-day operation of the company on a higher level.
Yes, Mr. Glassman, I'm sorry if I'm beating a dead horse here, but look through your motion for summary judgment and looking at the motion just from the perspective of the trial judge, at page 18 of the motion, where you talk about the reasonableness of the agreement, or in your case, the unreasonableness of it, you state that ESI must establish each factor by clear and convincing evidence. And then I read on at page 20, and again, as I mentioned, it's, the sentence here is that advocating the unreasonableness of the contract says binding young scientists with hardly any client contact weighs against enforceability of non-compete against former employees. And then again at page 22, once again indicate that ESI, when compared with ESI's current advertised capabilities, its attempt to stifle young scientists from using their education and experience prevents ESI from establishing by clear and convincing evidence that the non-compete is not greater than required for the protection. And finally, the last instance at page 25, again, you're speaking once again about the unenforceability of the non-compete. It says this factor, education and training, tips the scales heavily towards the unenforceability of the non-compete. And as I said, I'm not trying to beat a dead horse, but it seems to me that you're arguing that this trial court, number one, should apply the wrong standard, and number two, needs to weigh these factors, or the non-factors.
I'll take your questions, if I can, a little bit out of order.
Okay.
I think you're, in the context that it was used in the motion, I think your way is being taken a little bit too literally.
Yeah, but the judge is reading it and said, well, that all sounds good to me, and I guess I can weigh these factors.
And weigh can mean different things. It can be, balancing. It can just be, okay, when I'm weighing things, this is everything I know I need to consider in the context of deciding the motion. So I don't think here, there's nothing in the trial court decision where the trial court, because the trial court, came out of the gate saying, this is a summary judgment case, and in order to grant summary judgment, here's what the moving party needs to establish. So clearly the trial court knew this was a summary judgment case and knew what had to be done. So because of that, you don't see, I think there was a reference in Wigton to the court putting their thumb on the scale. You didn't have that here where the trial court was saying, well, I'm going to believe this witness, but I'm not going to believe that witness. You don't have that here because, again, we had cross motions, so nobody felt that there was a factual issue. And just going back to what I mentioned a little bit earlier, even if you disagree with me and continue to apply Wigton, even under the Wigton standard, if you were to review this case in a de novo context, we still think the 9 factors cut in our favor, and even under that sort of review, summary judgment should still be granted in favor of the appellee.
Thank you.
Unless there are any other questions, I just ask that the decision be affirmed, and I thank you for your time this morning.
Thank you. Thank you for your argument. Attorney Argo, can you please address, were there any material issues of fact?
Yes, I certainly can, and we believe that there are, because what the issue of fact, and when the court is looking at the 4th and 5th factors here. Whether the covenant seeks to eliminate competition would be unfair to the employer or merely seeks to eliminate ordinary competition, and whether the covenant seeks to stifle the inherent skill and experience of the employee. What's very important here is that the court understand that we're not seeking to stifle those employees from ever being employed. They could have been hired by Edge. It's the use of their permits. So if you back up and look at what facts is going on here, you have actually Edge was a customer of ESI because they didn't have the skill and experience that these employees did. And then what they did is did an end around and essentially bought that business out from underneath ESI. And that's unfair. The facts, there are a lot of disputed facts, and the court, all they say is that they assessed the agreements, the affidavits, and the notes. They don't even claim that they looked at the affidavits, at the deposition transcripts. There clearly is an issue of fact. And more importantly, backing up for this court, this is a tortious, this claim that was dismissed on motion for summary judgment is a tortious interference with contracts. And the court then says that the plaintiff had to, in assessing the reasonableness of the contract, that they had to establish each factor by clear and convincing evidence. And that flies directly in the face of Wigden and makes the point that Judge Winkler here was raising. I think he answered your question better than I did initially, that yes, the weighing of factors inherently means that they're assessing and doing that analysis that is not appropriate at a summary judgment stand.
So let me ask you this. Factor 4 and 5, which I think you just cited, and I had previously cited, and let's do them individually. So factor 4, is that a determination of fact or a determination of law?
I believe that there are facts that, and if
There's
you
always going to be facts
yes.
that factor in. But
Yeah,
the point is, when it gets all computed, that determination is made, is that going to be a determination of fact or a determination of law?
I mean, I think when you consider the 9 factors, it is a determination of law at some point. Yes,
Right.
each of
The
them.
outcome of whether it's enforceable or not is a determination of law.
But
what
then
I'm
whether
asking is factor 4, whether that is a determination of fact or law.
I believe that it's a determination of fact. You have to, each case, they go out of their way, the Wigden case. And all of these cases, even the cases that the other side cites, it's like each case is so very fact specific. And so when the court is weighing facts, they've committed the error as cited in Wigden.
So with regard to the 5th factor, would that be your same position, that that's a determination of fact?
Yes.
So under that, couldn't it be said that the issue of law of enforceability in very rare circumstances could be disposed of on summary judgment?
I agree with that, yes. In very rare circumstances, if any, I mean, when you look at this record that is so significant, you have the parties talking past each other. The facts, the dispute of fact is there. We feel that the record, when employees are, admitting that they had non-competes, that they're being told by their in-house counsel that they're not enforceable, don't worry about it, that he says, hey, Casey Swecker says directly to Edge, you're getting this for free. How is all of those factors, I mean, that's nowhere in this decision.
Okay. Could you point to any cases that would support the proposition, even if it doesn't support it by specifically stating it, that enforceability of a non-compete, that ultimately is rarely going to be disposed of at summary judgment?
Well, I think the reality of it is, given the Wigden and the Castillo cases, I mean, this Wigden case really walks the court through that analysis. So it depends on what relief you're seeking. So injunctive relief, it's clear and convincing, and perhaps it might be more apt to fail or whatever. But in this context, when the court starts weighing the evidence and making those determinations, it has violated the standard of a motion for summary judgment. I really have to say, when you look at the judge's wording himself, he was assessing the reasonableness of that contract. That's the heart of this claim. And then he goes on to say, you have to establish each factor by clear and convincing evidence. That's plain error. he has placed too high a burden on ESI at the motion for summary judgment stage. And so it truly is a procedural anomaly of injunctive relief versus motion for summary judgment. I don't know that I found cases in preparing that say you're never going to be able to grant summary judgment.
Well, it doesn't have to be, again, a case that specifically says that.
Yes.
But that, in going through these factors, because when I look at the other factors, whether the agreement contains time and space limitations, that seems to be a pretty, either it does or it doesn't, and what are they, right?
Correct.
So, but when I get to 4 and 5, it seems to be a little bit different as to what's going to, how, this sort of the calls that the trial court will be making.
And yes, and I would actually agree and point to factors 7 and 8 as well. I think those are highly factual. When what's disturbing about the lower court's decision here.
Well, I think 7, whether the skills that the agreement seeks to restrain are actually developed during the employment. Is that one of the ones you just cited?
7, yet whether.
The agreement bars the employee's sole means of support.
Yeah, I'm looking at sole means of support and whether the employee's talent, which the employer seeks to suppress, was actually, during the time period. Yes, Your Honor. And in those, what's interesting is the judge did not go through each of these employees and do the assessment for each of the parties that had an employment agreement. He pointed to it, the generic language in one agreement, claims he looked at some affidavits and then made some notes about them. So it's not clear, that the court even analyzed under the appropriate summary judgment standard, looking at the entirety of the record for each of these employees. He just lumped them together, found the clear and convincing standard, and we believe that that's not appropriate. We believe that the court should be remanded with instruction, to assess the claims under the appropriate standard and to consider each motion for summary judgment with its full weight, with all factors.
I have a fairly academic question. I'm looking at the complaint signed by Mr. Roberts, and prayer for relief is an award of temporary, preliminary, and permanent injunctions set forth above. And my understanding is, I know that I think Mr. Glassman filed the motion for summary judgment first, and then maybe you felt compelled to file one as well. But my question is, how did you restrain Mr. Roberts from not moving forward on a temporary, preliminary, or permanent injunction? Because it's been my experience that I'd look back in the courtroom and I'd see him back there waving around papers, and next thing I knew I was in a preliminary injunction.
Yes, so
That's supposed to be humorous. I'm just asking, why did you not go forward on those?
I think that as the case progressed, they took this very seriously, and then they, decided that they bypassed, just like Wigden, they bypassed the injunctive relief,
Okay.
and thought, that we really need to go forward.
In summary judgment? Okay.
Yes.
Okay. That was supposed to be humorous, Mr. Roberts.
Okay.
Okay, thank you.
Yes. It's a bad day when I have to answer for Mr. Roberts. So. Okay. Anyway, does the court have any other questions? I do think that, looking at the Wigden decision and the binding authority before this court, we would seek, see that there's reversible error and ask that the court remand.
Thank
Thank
you.
you.
Are we going to stay in here? Are we going to stay in here? Okay, it's up to you.
Thank you both for your arguments this morning. We're going to take the matter under submission, and we will issue a timely decision. Thank you both. Have a good afternoon.
All rise. The Court of Appeals, First Appellate District of Ohio is now adjourned.
We're going to be staying on the bench because we have a guest, but you can turn off the system.